everyone, and good afternoon and evening to our friends joining us from across the time zones. A very warm welcome to this panel discussion organized by World Law Group. World Law Group is a global network of 61 premier independent law firms that covers 94 jurisdictions. It collaborates globally through 17 practice and industry groups. And this meeting today is hosted by our Compliance and Investigations Group. Everyone has been muted upon entry. Please remain muted throughout. We do intend, time permitting, to have Q&A at the end. So please feel free to drop your questions into the chat. In this panel discussion, investigations lawyers from 6 of the World Law Group's jurisdictions across the Asia Pacific will discuss key topics on internal investigations. We will focus on 3 areas. What are typical ways to set up and scope an internal investigation? Does each jurisdiction recognize any privilege to protect attorney-client communications? And what are the kinds of reporting obligations to be considered in each jurisdiction? I'm very glad to have with me lawyers from Australia, China, Japan, South Korea, and Vietnam. And I am going to introduce them to you in alphabetical order of jurisdiction. So from Australia, we have Philip Stefanowski, a disputes partner in Minter Ellisons, who specializes in financial crime and regulation. Phil spent some time in-house with Morgan Stanley as acting financial crime counsel for Europe and the Middle East, so he brings an in-house perspective to the table. From China, hopefully joining us soon, we have Kent Wu, a senior practitioner from Zonglun Law Firm, who also spent some time as in-house counsel at a major US IT company in Beijing, so he would bring a unique perspective to this topic. From Japan, we have Akira Nagasaki and Nayuki Kishimi from Citi Yua Partners. Nayuki-san was a former prosecutor, so he is extremely knowledgeable in this particular area. From South Korea, we have my good friend Hangil Lee from the leading firm of Bae Kim and Lee. Hangil is dual qualified in Korea and the state of New York, and she specializes in international arbitration and cross-border litigation. From Vietnam, last but not least, we have Doan Nhat Min, a disputes lawyer from preeminent firm Vilaf. He is experienced with dispute resolution at the Vietnamese court, the VIAC, the SIAC, and the ICC. I'm Joy Tan. I lead the investigations practice in Wong Partnership in Singapore, and I'll be your moderator this morning. Wong Partnership is proud to be the Singapore firm for WLG. As most of you know, we are a full service firm in Singapore, and we are now the 2nd largest firm here. So I will look to kick things off by discussing the position in Singapore. And then I'm hoping to turn it over to my fellow panelists, after which, if there is enough time, we'll have a very short Q&A. So again, please feel free to post your questions in the chat. So in Singapore, the position on privilege and reporting is similar to the one in Australia. We're a common law country. We draw from UK traditions. We have judge-made laws as well as statute. And you know, as with many common law jurisdictions, we have robust protections given to legal advice. And these have shaped the sort of best practices in internal investigations here. The position has some similarity with China, but it's different in Japan and South Korea, and I want to say very different in Vietnam, as you will hear from my fellow panelists. And this means that though the setup of your internal investigation might look very similar across the jurisdictions, the position on both privilege and reporting may be very different. And this is, of course, very important when you have an investigation that involves those other jurisdictions, and means that, you know, when you consider your investigation setup from the perspective of privilege and reporting, you should do it in all relevant jurisdictions to ensure that privilege and protections are maximized and enable better decision-making. So the first slide that I have for Singapore discusses the various phases of a typical internal investigation. First, you'll see the sort of scope and the terms of reference. Second, the evidence gathering phase. Then third, the investigation report and the communications that you engage in with third parties and the investigators. And fourth, the statutory and regulatory reporting phase, if any, in light of applicable obligations. And across the jurisdictions, this is the commonality of the process. It's one that's designed to thoroughly investigate the misconduct in light of any applicable reporting obligations, while at the same time seeking to maximize legal privilege. So of course, the first phase of your investigation is often seen as the more important one. You need to have a good terms of reference, which is necessary to determine the parameters of your investigation, to set the clear protocols for the investigation team, and identify and clarify the investigation goals, including reporting obligations. So the key balance to strike here in terms of scope is between being thorough on the one hand and boiling the ocean on the other, right? And the last aspect is, in my view, equally important. I mean, if you are a listed company or a financial institution in Singapore, you will have investigative and reporting obligations to your shareholders or the Monetary Authority of Singapore. And if so, you would be engaging in an internal investigation to obtain legal advice on whether that kind of reporting is triggered in this case. It may also be an important defense mechanism to address regulatory and prosecutorial investigations that might be on the way, as well as any third-party claims. Conversely, if you are a private company with little risk of reporting requirements, then the concern might be how to maximize privilege over your investigations until you're ready to consider self-reporting. And sometimes clients will decide not to self-report if there is no obligation to do so, although, of course, self-reporting and cooperation may be beneficial. Singapore has enacted a new deferred prosecution regime, pursuant to which leniency from prosecution of certain crimes may be obtained as a result of self-reporting. The middle two phases of the process, at least in Singapore, are key parts in the whole scheme of things, where missteps may be made and privilege may be lost. But in the interest of time, let me move to the next slide and discuss the privilege as it exists in Singapore in that context. So in Singapore, there are two types of legal professional privilege. First, legal advice privilege, which covers all confidential communication made between the client and its lawyer for the dominant purpose of obtaining legal advice, whether or not litigation is contemplated. So if your company decides to conduct an internal investigation and litigation is not yet in contemplation, but you want to cloak the investigation with privilege until your board decides what to do, then you're looking at legal advice privilege. The point to note is, it doesn't ordinarily extend to communications with third parties unless that third party is an agent of the client. So a good investigation protocol will restrict third-party communications. The position in Singapore regarding, who is authorized to receive the legal advice is more flexible than in the UK. I understand it's similar to Australia, but in order to maintain the privilege, it's still advisable when you're drawing up your investigation protocol to ensure that there is a clear line of communication between such authorized person or its special board committee and the lawyers on the one hand, and then to the decision makers on the other, right? The second type of privilege is litigation privilege, and this covers all communications between the client, the lawyers, and other third parties made for the predominant purpose of litigation. The privilege doesn't automatically arise just because the company decides to commence an investigation. It'll only arise because the company did that, thinking that there is at least a reasonable prospect of litigation. What does litigation cover in this context? It does include defending an anticipated regulatory action that is adversarial in nature. And it's as long as it's not administrative, but adversarial, that's the important distinction for Singapore. So if your investigation is, in order to defend yourself against prosecution from anti-money laundering or some form of disciplinary action taken by RegCo, which is the listed company regulator, then this privilege should be available for your investigation. I think the concern to note with both these privileges is that in order to claim the privilege, the document must have come into existence for the dominant purpose of either seeking the legal advice or the contemplated litigation. You can have other purposes as long as those purposes are secondary. And of course, it's a factual inquiry as to what the purpose of any document or any litigation is. But there have been cases, including in Singapore, where the courts find the privilege didn't exist because the dominant purpose of the investigation was fact-finding and not to defend against litigation or seek legal advice. And I understand that that's a similar issue in Australia. And Phil will share with us what they try to do to address that concern. Right? 3 final points on the slide. In-house counsel can attract the privilege. There is statutory recognition on that aspect, as long as he or she is giving legal advice. This is not the case in some of the other jurisdictions, and the panelists will walk us through that aspect. In terms of waiver of privilege, Singapore does recognize the doctrine of limited waiver, which means a company can turn over privileged material on a limited basis and still maintain privilege against others, for instance, against any third parties. In terms of cooperation, as I mentioned, Singapore did pass legislation enabling UK-style deferred prosecution agreements, which means companies can obtain a deferral of prosecution by self-reporting and committing to some form of remediation. The last point I want to make before leaving the slide is I think our colleagues from Japan and South Korea will discuss their new antitrust legislation, which offers a leniency regime. In Singapore, we similarly have an antitrust leniency regime in exchange for cooperation. If I might just turn to the last slide very briefly, I'll say that this sets out the various reporting obligations in Singapore, but I was going to pass over that in the interest of time, and the slide does set them out. Basically, if you're not a listed company or an FI, you're only obliged to report on the first bullet point, money laundering, or the last bullet point, serious public order crimes. I would wrap up by saying, however, that just because reporting obligations aren't triggered in Singapore doesn't mean you shouldn't be self-reporting anyway. And the firm, Wong Partnership, we're well placed to help corporates navigate the self-reporting process and the potential to seek DPAs or cartel leniency. And with that, I was going to turn this over to Australia and to Phil from Minter Ellison. Phil.
Thanks, Joy. Maybe before I get started on the substantive part of the presentation, I'll just touch on Minter Ellison on this first slide. So a lot of you have probably heard of us. Minter Ellison is Australia's largest law firm with over 2,500 employees across offices in each of the mainland capital cities and also offices in New Zealand, Europe and Asia. We're a full service law firm dedicated obviously to providing strategic and commercial solutions to our clients, and often working in collaboration with our network of trusted firms through the World Law Group, some of whom you have heard from and you will hear from today. The time is short, so we'll jump into the next slide. And the Singapore position is not very different to the Australia position, so I'll try not to cover a lot of the things that Joy has already covered. But what I wanted to talk about this slide is 3 major points to raise, and that was the questions of who will supervise the investigation, the terms of reference, and then touching on really why timing is a crucial element of sort of how you conduct an investigation. Starting with who will supervise an investigation, that's an important concept to get clear at the outset. And it's not because of the narrow instructor view that maybe the UK has, which hasn't really made its way to Australia. But there's certain reasons why you have to decide whether an investigation will be run by management or the board. And often management is the starting point, and a really good starting point to have. But there are circumstances where the board may actually be more appropriate to be the conductor in the investigation. And this generally arises in 2 scenarios. One is when the seriousness of the matters being investigated are such that it makes sense for the board to be the conductor investigation. So for example, if management is implicated in the potential misconduct, you want to bypass management and go straight to the board. Secondly is where there's a risk of personal liability for the directors. So in Australia, directors can be personally liable for things like breaches of directors' duties, which includes failing to make reasonable inquiries or to investigate red flags. There are also obligations to take reasonable steps in complying with reporting obligations and to avoid trading while insolvent. So if these are the types of things that are touched on in the investigation, it might be that the board is better placed to have carriage of that. Moving then on to the terms of reference, in addition to who's conducting it, you need to have clear terms of reference and investigation protocols from the outset, which have clear lines of supervision and milestones for reporting. And as we'll touch on the next slide in a second, there's privilege, which works similar to the way it does in Singapore, is all determined on purpose. And so you want to, from the outset, make clear the purpose of the investigation and the connection between the work being done and the documents being produced and the legal advice or the contemplated proceedings. As a secondary step, you want the communication protocol that sits under that purpose to ensure the maintenance of that privilege by making sure information is not disseminated so widely that you're in effect waiving the privilege that you've worked to ensure you have. The only other thing I'll note is the green part of this slide, which is there should be a protocol for red flags to be reported and to be reported immediately, particularly where they trigger statutory reporting obligations, which I'll touch on in a future slide. The last thing before I move on is this concept of time being of the essence. So you really want to get a lay of the land in a short time frame, which will help you firstly rescope the investigation if it's been cast too narrowly, and also keep you a step ahead of potentially a regulator's investigation. So, if you're doing an internal investigation, a regulator might not be too far behind, and you want to know what to say when they come knocking. And you also want to be in a position where if there are red flags that have been picked up that require disclosure, that you have done that disclosure before. So you've done a proactive step rather than a reactive step of when the regulator is actually, looking themselves. Now to move on to privilege. So Australia does recognise the doctrine of legal professional privilege, and similar to Singapore, it's where a document is created for the dominant purpose, not necessarily the sole purpose, but the dominant purpose of obtaining legal advice, or it's created for the purpose of litigation. And that could be current litigation or reasonably contemplated litigation. Once a document has this protection, it's immune from compulsory disclosure. So a regulator can't force you to hand it over, except in very limited circumstances, such as royal commissions or the like, where there's statutory provisions which allow the bypass of privilege. What I wanted to talk about is, and Joy alluded to this, is where this comes up in internal investigation is where there are non-legal advice purposes to an investigation. So privilege can't be used to mask an investigation which would otherwise not be protected by privilege, because the purposes are beyond, legal advice or the connection with litigation. So, for example, if a report is being prepared into the cause of a major incident or an operational issue or compliance with internal policies, a court might say, well, this is not for the dominant purpose of legal advice. This is just your cause and effect report, and so you lose that protection. A way that this is sometimes handled is to actually split an investigation. And so a company will have a fact-finding investigation of the cause of an incident, and that won't be protected by privilege, and then a separate report on the potential liability or obligations that are owed, which is legal and does attract that privilege. Lastly, just touching on the position as between your regulators. As we said, the regulators can't compel the waiver of privilege, and there's no automatic discount for handing over privileged material. But as in a lot of other jurisdictions, cooperation is a factor that the court considers in appointing a penalty or a criminal conviction. So it's something to always consider, and there is the ability to enter disclosure agreements with regulators such that disclosure to them is a limited disclosure, such that it's not waiving privilege in the document, fulsomely to every other party. I'll pass on just to the next slide, if that's possible, on the reporting obligations. And so Australia has a lot of reporting obligations and a lot of obligations to self-report. And I guess the starting point of this is for listed companies. There's continuous disclosure obligations to the ASX, where the disclosure to the market has to be if there's any information that a reasonable person would expect to have a material effect on the value of the company's securities. So if the investigation doesn't cover anything like that, the market really has to be updated quite quickly. You might need a trading halt. Yeah, there are different triggers which actually require quite a speedy response to make sure the market's up to date. The second dot point there is touching on the anti-money laundering obligations, and in Australia there's a quick turnaround time to report certain types of transactions, and the two largest fines in Australia's history of regulation of all regulators are related to anti-money laundering breaches. Two of the large banks, one last year got fined $1.3 billion, and a few years before that, one got fined $700 million for anti-money laundering breaches. Just quickly, there's industry-specific reporting obligations. A lot of these in the financial services industry, where there's a self-reporting of serious breaches, and then lastly to touch on where there's sometimes non-mandatory obligations, but as Joyce said, it's still a consideration that you have to have of whether you should self-report in any case. And cartel conduct is a good example of that, where the first reporter has a first-in marker where they disclose potentially cartel conduct, and that allows them to apply for immunity for prosecution in exchange for cooperating with the investigation. So there are many points in an investigation time where you actually have to stop and consider, what are my reporting obligations? And even when it's not mandatory, still, is there a reason here where it's actually in the company's best interest? That concludes the whistle-stop tour of the Australian perspective. I think I've seen that Kent has just joined, so I'm going to pass over to Kent Wu, who will provide the Chinese perspective on internal investigations. Thank you.
Okay, thank you, Philip. So just a bit about Zhongluan. We are a full-service law firm with offices in many business centers in China. During last years, we helped many clients with internal investigations. So that's a topic I'm going to do today. Can I go to the next slide? Yeah. Okay. So setting up and scoping an international investigation in China is more or less the same like anywhere else. Because of that, I will not get into the details. But one thing important about China is that according to the criminal procedure law, any entity or individuals has the right and duty to report any crime. But in practice, this is not very strictly enforced. So basically, not all the internal investigation when there is a crime involved are reported to the police. But on the other hand, actually, one thing important in China is that if the reporting is going to be made to the police, actually the related evidence should be prepared in a thorough and sorted way, because white collar crime is still new to most of the police in China. Then I move to the legal profession privilege. Next slide. Yes. So U.S. style attorney or common law style attorney-client privilege does not exist in China. Attorney-client communication and attorney work produced enjoy privilege-like protection to a certain degree in China. Here you can see that Article 38 of the lawyer's law requires lawyers to keep confidential facts and information learned during the representation, which clients are unwilling to have disclosed. So that's a lawyer's privilege. And also Article 48 of the criminal procedure law take this requirement a step further by providing that defense lawyer have the right to keep confidential facts and information learned during the representation of clients. So the impact of this duty of confidentiality duty and right can be significant because actually discovery rules in China generally requires litigant to collect and produce their own evidence. Unlike in the US or other common law countries, a party to a litigation in China cannot request the other party to produce documents, answer questions, or participate in a deposition. Although the court may investigate and collect evidence, but in practice, they hardly ever collect evidence from or compel the production of evidence by litigants. So the combination of the confidentiality duty and right on the part of the lawyer and the very restrictive discovery rules means that attorney-client communication and attorney work products enjoy some protection in China. Having said so, in administrative investigation proceedings, enforcement authority also have a broad authority power to examine and to copy information documents relevant to the investigation. And also, no specific exceptions is made for attorney client communication or attorney work products. And although in practice, the enforcement authority generally do not demand cooperation from lawyers to the party subject to investigation and do not demand those lawyers to disclose confidential client information or attorney work products. But legally speaking, they have the legal authority and power to do so. So we talk about a little bit about the privilege of the lawyers, actually that is related to how lawyers define. Lawyers must fall into one of the following categories. One is the duly licensed Chinese lawyer practicing in the Chinese law firm, or a duly licensed foreign lawyers registered as the foreign lawyer and working in a representative office approved by the authority. So in that case, lawyers outside the definition are not considered as to have the privilege under Chinese law. So those people, including Chinese or foreign in-house legal counsel or unregistered foreign lawyers visiting or on assignments in China. And going back to the what we discussed, actually, for those people, according to the criminal procedure law, they have obligation and duty, right and obligation to report to the police. So basically, in-house counsel does not enjoy the privilege under Chinese law. Can I go to the next slide? Yes. Okay, and about the privilege of the lawyers, there are certain exceptions. So Article 48 of the criminal law provides a limited exception to the right of confidentiality. That is if there exists with respect to information or a crime being contemplated or committed that severely impairs national or public security or cause serious personal injury. So if there is a kind of a crime ongoing or contemplated, then there is an exception. And also, as the previous speaker discussed, in China there are also various stock exchange, and the listed companies are required to disclose major events which may have impact on its securities. And in addition, failure to disclose or disclose the information can give rise to a criminal offense. So basically, just to close, I would like to put some takeaway of my presentation. So the first one is to always maintain a panel of outside counsels who fall into the concept, the definition of lawyers, including the criminal defense lawyers, so that when it is desirable to move to matters from in-house counsel not covered by the privilege-like protection, it can be done immediately. And on the other, the second is that when retaining outside lawyers, be sure to include in the engagement letter a clear and broad request for confidentiality, since an expression of unwillingness to have disclosed on the part of the client seems necessary to bind lawyers under the lawyer's law in China. So that's my part. Coming down, let's welcome Akira and Naoyuki from CDUA Partners to talk about the situation in Japan.
Akira, I think you're muted.
Can you hear me now?
That's great.
Yes.
Okay, thanks. Sorry for that. Japan, we're CDUA Partners. Our firm, I'm working in the international branch, and Mr. Kishimi works, he's the ex-prosecutor, and he does lots of corporate investigations. Our firm has a very strong ex-prosecutor team and does lots of internal investigations for companies in trouble. And if there are any issues of that nature, we are very happy to help. And if it's something that has to do with international affairs, I will also join. So next slide, please. So in Japan, it's internal investigations are very similar to other jurisdictions. It's the same. We need to clarify the scope of the investigation and see whether there's other similar cases and organize a investigation team. And the investigation team, it depends on the scale of fraud, background, and management responsibility. So in the case of a company-wide fraud, the team is often organized by an independent panel of experts. So we have somebody from outside the company, and many times these are ex-prosecutors. They will help organize an investigation of the company and present a report. If it's a very small violation, like just one person that doesn't have any market effects, the investigation team is often recruited only internally, and a lawyer may be involved, but it's not like these independent panel of experts. In investigations, it's similar with other jurisdictions. There's interviews. Sometimes we do digital forensics, questionnaire documents, and we also have a whistleblowing system where the employees can raise an issue. And under the law, companies are not allowed to penalize employees for whistleblowing. Next slide, please. So what is very different from other jurisdictions, especially common law jurisdictions, is that Japan, we do not have any statute that recognizes attorney-client privilege, with one exception that I will explain later. For civil procedures, we do not have discovery. So it's not a big issue. It doesn't really matter because like in China, the parties need to present their own evidence, and you can't count on the evidence that the other party has. There is no discovery. For criminal procedures, we do have statute that allows certain professionals to refuse seizure of materials by law enforcement. It's under the Article 105 of the Code of Criminal Procedure. And as you can see, and this is a full translation, attorney, and this includes foreign lawyer registers in Japan, may refuse seizure of information that's related to the person that he or she is representing. But you have to note that this does not apply if law enforcement seizes material not held by these attorneys. The prosecutor's office or the police cannot go to a law firm and try to seize material there, but they can still go to the company and they can seize a lot of materials there. And since attorney-client privilege does not apply, all these materials, even if prepared by lawyers, they will go to law enforcement. And if the law enforcement sees them fit, they will go into court. So it's very different. Next slide, please. But there's one exception. The only exception is what we call a distinction procedure. If you can read, is it called Hanzi or Hanza? If you can read Chinese characters, you can understand what the Japanese government is trying to do here. It's called a distinction procedure. And from December 25, 2020, which is last year, certain communication will be subject to distinction for investigation by the JFTC, which is the Japan Fair Trade Commission. This is for violations subject to leniency, and these are typically cartels and bid rigging. So in order, some communications are protected, and protected communications must be between a client and a lawyer admitted in Japan. So it cannot be foreign admitted lawyers, and it needs to happen confidentially in nature, and it needs to have been an opinion given by the lawyer to the client regarding the issue subject to investigation. So this limited attorney-client privilege will apply. But we need to be careful that this will only apply to investigation made by the JFTC to impose administrative fines. And it will not apply to criminal investigations by law enforcement. So the prosecutor's office or the police can still go to your company and do investigations in violation of the Anti-Monopoly Act, but it will not apply to that procedure. But it's rare that happens. It's usually only the JFTC that enforces this. So on to the last slide. The next one. So in Japan, we do not have general self-reporting obligations. However, for listed companies, if there's something that has to do with what was disclosed in the market, like insider trading, false reporting, that needs to be disclosed. Other companies may still choose to disclose internal investigative reports to regain public trust, which is common. And if you check the Japanese news, you will see many companies doing that, and an ex-prosecutor gets on television and explains what's going on. And so that is all for Japan, and it's for Ms. Lee, South Korea.
Thank you, Akira. So good morning or good evening to everyone. BKL is one of the largest law firms in Korea with offices in Korea, China, Hong Kong, Vietnam, Dubai, and Indonesia. And as a full-service law firm with local and international counsel, we provide legal services to clients related to Korea. And one of our key services includes investigations and criminal matters with a variety of professionals. So next slide. In general, Korea's internal investigations are still at an early stage. So given the strong and broad power of law enforcement authorities, investigation activities are rather focused on how to respond to such government investigations. In addition to the traditional law enforcement authorities, such as police and prosecutor's office, tax agencies such as NTS, National Tax Service, and KFTC, such as Japan, the Korean Fair Trade Commission, are playing an important role, conducting down raids with a court-issued warrant and various types of on-site investigations. So turning to the internal investigation scheme, usually the internal investigation is triggered by way of compliance program of the listed companies over a certain threshold, or by an investigation notification to the corporation by the law enforcement. So for example, in April 2018, KFTC sent an examination report to Apple, seeking an explanation of its alleged unfair business practices. And Apple then applied for a consent order, maybe after the internal investigation, meaning that the company has initiated a process to close the case only by voluntarily agreeing to take corrective action. So these investigation notification triggered internal investigation is usually conducted to avoid any potential corporate liability, either civil or criminal. In practice, perhaps because the internal investigations practices are at an early stage, it is uncommon for an internal investigation to be conducted by external counsel. So in Korea, it is usually by the in-house counsel or compliance officer who administers the internal investigation itself. Still, interviews with witnesses and examination of emails, documents, or financial transactions are the typical means used during an internal investigation, if any. Although there is no established law or practice yet on how to conduct these internal investigations, it would be recommended that an investigation hold or litigation hold should be applied so that the relevant evidentiary materials should not be discarded and no additional criminal charges could be initiated. If the subject of the investigations are digital device or an email service server, search terms are usually used. And after the investigation, a white paper or a brief report would be prepared. But importantly, there is no obligation for a business to self-report its misconduct in general, which I will explain later. And there is, next slide. And now turning to the privilege issue, like Japan or China, the American or common law concept of attorney-client privilege or attorney work product privilege is not recognized in Korea. So court precedents are also not conclusive on the existence and scope of such privilege. While it is generally considered that the communications before the commencement of a criminal investigation or criminal proceedings is not recognized, it is unclear whether such privilege is not recognized even after the commencement of such proceedings. However, an attorney bears the confidential obligation and has the right to refuse seizure of objects under his or her custody during the course of the providing legal services and to testify confidential information in civil or criminal proceedings. Well, but the important point to note is that these duties and rights are only afforded to attorneys and the parties, so the client cannot assert that these rights once they are requested to produce such information during the investigations. And as noted from the outset, dawn raids and on-site investigations are frequently used by the law enforcement. And in December 2018, the offices of two lawyers at Kim and Chang, the largest law firm in Korea, were raided by prosecutors due to an allegations that the lawyers colluded with a former Chief Justice to intentionally delay the ruling in a case. And not only the prosecutors, but also tax agencies used the dawn raids, and police and tax agencies raided South Korea's largest cryptocurrency exchange at that time in early 2018 for alleged tax evasion. Also, there have been a few incidents in which the prosecutor's office has requested external legal counsel to submit materials exchanged between a client and its external legal counsel upon obtaining a search and seizure warrant from the court. So following these incidents, the South Korean legal industry has been making attempts to formally introduce attorney-client privilege into legislation, and we may expect that this will be coming. Next slide. So turning to the reporting obligations, as I have noted earlier, generally there is no obligation to share the results of an internal investigation with the government. No certain and express benefits are written in the laws or policies for such self-reporting. Nonetheless, there exists incentives for certain businesses to self-report. So in a formal criminal court proceeding, self-reporting is a mitigating factor in general in sentencing. But when it comes to cartel investigations, there is a written leniency policy, in fact, and it has become actually trend for self-reporting such misconduct. With some preconditions being satisfied, a self-reporter may be eligible for mitigation or exemption from sanctions. And further, if the parties provide the evidence necessary to prove the existence of a cartel voluntarily and independently, and has suspended the collusive practice and remains cooperative to the investigations, it may also be eligible for 50% reduction of any administrative surcharge and mitigation of any restraining order KFTC will be applying. So I think it will be all from South Korea's part, and we'll be moving on to Vietnam.
Yes, thank you very much. Hi everyone, I'm Ming. I'm currently a senior associate at VLab. As far as you may know, VLab was established in 1993 and since then has developed into a well-known law firm in Vietnam with approximately 80 lawyers working in Hanoi and Ho Chi Minh City offices. So we are a multi-service law firm providing legal service in almost all significant investment and business sectors in Vietnam, from infrastructure projects, M&A, capital market, banking, finance, and dispute resolution. So with regard to internal investigation, there seems to be not so many law firms in Vietnam that have experience in this field, but thanks to our diverse client base, including a lot of multinational corporations, VLab has the chance to work in several internal investigation, and therefore I am very glad to be here today to share with you about some notable issue in this regard under the laws of Vietnam. So first, about the setting up and scoping an internal investigation, I will not focus much on this because this is similar to what my fellow counsels have presented before. There will be in general, 4 stages. The first one, 3 stages. The first one is the scoping phase, where you form the terms of reference and the investigation team, like the basis for your investigation. And then it will move to the investigation phase with the investigation plan, when the document and information will be reviewed, interviews will be conducted, and sometimes third party may be engaged to collect more information and advice. And afterward, there will be the reporting phase, where a report will be prepared, which includes the steps taken during the investigation, the method of investigation, a summary of issue and findings, and legal advice, and also the action point for the client. And during the investigation phase, one of the most important things that the parties and the lawyer should take care is about the communication and the confidentiality obligation. And I will talk about the legal privilege in the next slide regarding to this one. Next slide, please. Okay, so under the laws of Vietnam, there's no concept of legal privilege. I think this is similar to several other civil law countries and similar to China, as Ken had presented before. The Vietnamese law has a similar concept, a similar approach to the confidentiality obligation of the lawyers, which is stipulated in the laws on lawyers, the Criminal Procedure Code, and the Vietnamese lawyers. And this provision will apply similarly to lawyers in law firm and in-house counsel if the in-house counsel are lawyers with lawyer practicing license. So there's no kind of difference between in-house lawyer and lawyers in law firm, provided that they both have the license for practicing in Vietnam. So the next slide, please. And as you can see, in Vietnam, the reporting obligation is quite vague. So under Article 19.1 of the 2015 Penal Code of Vietnam, it is required that a person who clearly knows that a crime under Article 389 is being prepared, is committed, or has been committed, shall be subject to the criminal liability if he or she does not denounce such crime. So under Article 389 of the 2015 Penal Code, there's a lot of serious crime, such as the murder, rape, and especially crimes relating to bribery and fraud. So in case an investigation is conducted and there is some kind or signal of bribery, for example, the question is very hard for the company to decide whether they should denounce that or report that to the authority or not. This is because on one side they may have the information, they may have some kind of evidence that related to such crime, but it may, on the other side, it may not constitute the criteria of clearly knows the requirement of the law about crime. And of course, I think that most corporate does not want to disclose this kind of information to the authority, and they want to settle it internally. So this is, however, this is still need to be taken into consideration when you're doing an investigation. And I just want to share with you that in practice, this provision about the denouncement of crime is quite kind of untested in Vietnam with regard to investigation. So we have not seen any case, any criminal case that a person who failed to report about the investigation result to the authority is prosecuted with this kind of crime. So after all, I think that there are some takeaways for you in Vietnam regarding to the investigation. The first one is that although Vietnam does not have the legal privilege, but since the investigation is normally conducted involving foreign lawyers and Vietnamese lawyer, the code of conduct, the communication and the method should still be protected to ensure the legal privilege for foreign lawyers. And the second thing is that a reporting obligation is provided under the laws of Vietnam, but it is untested in practice. So that's what I want to share with you today. Thank you.
Thank you very much, Min and everyone for speaking to us today. I'm told that we have run out of time for Q&A, but what we will do is gather the questions that have been posted in the chat and try to respond briefly to them via email later. And what our plan is also is to prepare a summary table on the substantive issues that each jurisdiction discussed here, the commonalities as well as the differences. So in summary, for Singapore and Australia, we've seen that there's broad privilege protection for investigation materials from both civil discovery and criminal seizure, but contrasting that with the broad AML reporting obligations and listed company FI reporting. For China, Japan, and South Korea, there's no privilege against criminal seizure of documents in the hands of clients. And in South Korea, despite the existence of confidentiality, on lawyers, there have been raids on law firms, right? But sort of contrast that, against the fact that there is no civil discovery and very few reporting obligations, more in Japan, but less in the other jurisdictions. And we understand that regulators seldom ask for internal investigation reports, although cartels, it's a special category, right? And we've heard that in Vietnam, there's no privilege also, as well as a certain amount of mandatory criminal reporting, although this isn't tested. So everyone on the call, if you have an Asia Pac cartel case involving 6 jurisdictions, now you know how to structure your investigation. And if you, for non-cartel investigations, I think the takeaway there, particularly if you've got Japanese, South Korean, or Vietnamese clients, is never leave any investigation material in their hands. Always, and the clients might never have to self-report anyway. Make sure that if you've got anything controversial in those jurisdictions, you leave them in the hands of registered lawyers, right? So, and as I say, we'll look to circle back to the group here with a summary table that covers all the jurisdictions. So really, it remains for me to thank my fellow panelists and investigation practitioners, Phil, Kent, Akira-san, Nayuki-san, Hengil, Min, and to Hannah from World Law Group for facilitating. Thanks for a great presentation, and of course to all of you who've dialed in for attending today. And if there are any further questions that you have, please feel to reach out to each of us or to World Law Group. You would have gotten the contact details, or when you signed up for the seminar, feel free to reach out.